Hello and welcome to our webinar, Workers' Compensation Updates and Considerations in the ongoing era of remote work. Before I introduce myself and our speakers, please see the information slide that is on your screen right now. My name is David Marchione. I'm an occupational health and safety consultant and paralegal in Fasken's Toronto office in the Labor, Employment and Human Rights Group. I'm joined today by my colleagues Richard Savage, Counsel in our Vancouver office, and Isabelle Duclos, Associate in our Montreal office. In today's presentation, we're going to be providing an update on some recent changes to workers' compensation law across Canada, and we'll be discussing some recent cases in the workers' compensation sphere. We'll finish off today's presentation by talking about some health and safety and workers' compensation considerations in the ongoing era of remote work. So let's get started in the presentation. I'm going to turn it over to Richard to start things off.
Thank you, David. I just have a brief legislative update regarding British Columbia. Bill 5 received royal assent March 10th, 2022, so hot off the presses. And this bill grants Wsib additional powers to introduce new standards under the Workers' Compensation Act that will require asbestos abatement contractors to be licensed to operate in British Columbia. This will require workers and employers who perform this type of work to complete mandatory safety training and certification. Asbestos abatement work includes assessing, removing, repairing, or transporting disposal of materials containing asbestos, and is a significant concern in the construction industry. Since 2000, asbestos has caused more than 50% of all work-related occupational disease deaths in British Columbia, so it's still the primary killer in British Columbia in the workplace, and causes more than 33% of all work-related deaths in BC. These proposed amendments will help strengthen the existing regulatory framework regarding asbestos abatement work. Until now, BC hasn't had a comprehensive licensing regime, and Wsib has dealt with repeated concerns for unsafe handling disposal practices by contractors who engage untrained or undertrained workers. Another policy update regarding policy review. Wsib has extended to January its consultations regarding changes to contractor status in British Columbia. It extended the consultations because of the feedback it was receiving, and it's reviewing that stakeholder feedback now. Just so you know, this was to do with the test for independent firm status in BC. Unlike other jurisdictions or other administrative bodies in the tax court, BC had an intermediate status of labor contractor, and they're looking to do away with that and simplify the test and harmonize it with the test used at the common law for an independent contractor or used by other administrative bodies. The industries that will see these changes mostly be impacted them are construction, forestry, and likely the gig economy, where we're seeing a lot of questions about status in various jurisdictions. I'm now going to turn it over to David to discuss legislative updates in the rest of Western Canada and Ontario.
Thanks, Richard. Interesting that the policy review is taking place for independent contractor status in BC. It is a very, very common problem or common issue, especially in the gig economy, and a lot of questions coming out from that. Just moving along with the legislative updates, in Manitoba, Bill 31 was introduced and went through first reading just very recently, again, March 17th, 2022. That bill looks to amend the Workers' Compensation Act and includes a requirement for keeping records of wages earned by all employees and a requirement to provide those records to the Compensation Board upon request. The current version of the Workers' Compensation Act does already include a requirement to keep records, but does not include a requirement to provide those records to the board upon request. Generally, the requirement goes along with any review done by the Compensation Board to ensure that employers are properly reporting their premiums in order to make sure they're complying with the Act. The Act regulations are expected to be introduced that will specify time limits for retaining those records and for providing them to the board when the records are requested. Next slide, please. In Ontario, the Workplace Safety and Insurance Board hasn't had any significant legislative updates. There has been an ongoing policy consultation for occupational diseases. There was a public consultation that took place between November the 30th of 2021 and February the 28th of 2022. Stakeholder feedback was sought in order to provide feedback to the WSIB on developing occupational disease policies and updating its policies so that they can keep up with being able to adjudicate occupational disease claims based on the most recent or the latest scientific data. This is especially important in high-risk industries such as mining, construction, and with, as we've seen in the past, with first responders. For example, not too long ago, there were some changes that were put into place with respect to firefighters and occupational diseases, where in the past, there had to be specific evidence of an occupational disease. Now there are presumptions in place where if a person worked in a certain industry, for example, if they were a firefighter and they developed a certain type of disease, then it's presumed to have arisen out of their employment. So that policy consultation continues, and we'll expect to see some updated policies in the near future. On January 1st of 2020, the Workplace Safety and Insurance Board introduced its rate framework, the new experience rating system that updated all of the existing experience rating and changed it from the three separate types of experience rating for employers that they had, and there were some employers who were not experience rated at all because of their size. Now all employers are experience rated under the rate framework, which is very similar to the experience rating systems that are used across the country. Under the current experience rating system, or under the rate framework system, the WSIB calculates an employer's premium for the upcoming year based on three criteria: the number of claims the employer has had, both lost time and no lost time, their insurable earnings, so the size of the employer, and claim costs over the past 6 years. So claims costs do impact an employer for 6 years from the date of injury. The WSIB was phasing in and continues to phase in the rate framework, and the amount of the adjustment to an employer's premium is limited until the phase-in period is completed. So the experience rating system is being phased in. That will be completed in 2024, when it will be, as the WSIB refers to it, fully operational. At that time, the maximum increase or decrease an employer could see in any given year would be approximately 15% from their current premium rate. So continue to watch that, and updates will come as the program continues. Earlier this year, the WSIB announced that it would be rebating $1.5 billion in surplus premiums back to employers, and the reason for that surplus is the WSIB's investment strategy and limited or lower numbers or lower amounts of monies being paid out for various reasons. So it has a $1.5 billion surplus that it is rebating to eligible employers. Employers become eligible for that rebate if they had an active account with the WSIB as of January the 31st of 2022. If they had premium obligations to the WSIB in 2019 or 2020, so it's not sufficient just to have an open account. You had to have been paying premiums in 2019 or 2020. The employer could not have been convicted of an offense under the Workplace Safety and Insurance Act or Part 3 of the Provincial Offences Act related to any occupational health and safety offense. in 2021 or 2022, up to and including the date that the rebates are issued. And the employer cannot have been convicted in more than one such proceeding between 2017 and 2022, up until the rebates are issued. It's anticipated that those rebates are going to be approximately 30% of the employer's premium paid in 2019 or 2020, whichever is higher. To the question about why the WSIB is looking at 2019 and 2020, the answer is that the WSIB is aware that because of COVID-19, and an employer's insurable earnings may have been lower in later part of 2020 and 2021 due to people being off work. So they're looking at 2019 and 2020 instead. I'm going to turn it over to Isabelle.
Hi, everybody. So I'm doing the Quebec part. And as you know, or may not know, there was some major changes. So the Act to modernize the occupational health and safety regime in Quebec received royal assent on October 6, 2021. Various changes are now in force or will be in the next few months, years too. So upcoming, we do have April 6th, October 6th, January 1st of 2023, and then we have other dates upcoming. So we can change slides. So the purpose of this act is to modernize the occupational health and safety regime with regard to prevention of and compensation of employment injury. These changes include amendments or additions to the existing regime. For example, the Act respecting industrial accidents and occupational diseases, the Act respecting occupational health and safety. So some changes are already in force since October 6th and include remote work. The Act now specifies the notion of telework in order to ensure the application of the OHSA to teleworking workers. In doing so, the Act now provides for the employer's obligation to ensure the health and safety of a worker who works from home, and this is regardless of whether work is done at the worker's home or in another place, for example, a cafe. It is therefore in the employer's interest to provide a clear policy on telework and regulate the provision of telework. We also had spousal violence. The employer must take the necessary measures to ensure the protection of a worker exposed to a situation of physical or psychological violence, including situations like domestic, family, or sexual violence. The employer is required to take action when he knows or ought reasonably to know that the worker is exposed to domestic or family violence, and this is important, regardless of whether the worker's place is located. So in other words, the employer's obligation extends to situation experienced by the worker, even when they occur at his home while the worker is working from home. We can change slide. So here I listed another example of changes. So here are other examples already in force. For the diseases, the Act enacts the regulation respecting occupational diseases, which determines diseases for the purpose of the application of the occupational disease presumption, as well as the special conditions in relation to those diseases. They also increase the amount of fines. Students ongoing a job, shadowing, or work training period under the responsibility of an educational institution are protected under the Act. The Commission is now allowed to put in place an employer certification program in order to promote employers taking charge of health and safety in the workplace. concerning hearing impairment are now recognized as is no longer directly attributed to the employer's file. The obligation of employment in agency with respect to health and safety are now denied, and it is prohibited for them to transfer or limit their obligation by contract to another party. For building owners with at least one employer occupying the premises now have an obligation to protect the health and safety of workers in space that are not under the authority of an employer. With regard to upcoming changes, we have, and this upcoming changes is April and October and all the upcoming dates. We have the creation of an interim regime. This is the implementation of an interim regime to allow a temporary solution regarding prevention until the adoption of the regulation concerning the prevention mechanisms, which will provide more clarification. More specifically, this regime will impose prevention and participation mechanisms depending on the numbers of workers. And we will be putting a link on the CNSST. They did provide a tool so you can know in which group you will be. We also can, there will also be an inclusion of domestic workers to various protection when they meet the criteria. There will be a limitation of 7 years to make a claim in case of a diseased worker. The power of the Bureau d'évaluation médicale are revised with respect to the consolidation of an employment injury. We will now have only one form of temporary assignment with 2 options of payments for the employers. There will also be new rehabilitation measures. The Commission will be able to grant rehabilitation measures before the consolidation of an employment injury. This will broaden the measures that the Commission and employers may take to favor workers' reinstatement in their employment, including the Commission's obligation to offer job search support services and assistance services to workers. So job search support will be in place. We will also have accommodation. Measures will be precise and the process will be defined in according to the ongoing case law. So to conclude, the first wave of changes has an impact on your day-to-day management. Among all things, internal procedures, current practices, and policies will need to be revised and updated to reflect these changes. Updating the training of managers and employees on the new concepts is also essential. So now we're going to be in the case law part. And I will be presenting the Air Canada case for the Quebec part. So let's start with the facts. In this decision, we had a teleworking client agent that worked from home and fell down the stairs a few minutes after her lunch break had started. So the court analyzes the concept of arising in the course of an industrial accident, or as we all know in Quebec as à l'occasion du travail. When analyzing this concept, the court traditionally looks at the activity if the activity happened in the personal or professional sphere. To do so, the court analyzes the purpose of the activity, if it is a work-related activity, and the concept of subordination. The decision on whether or not a claim will be accepted will be taken on a case-by-case basis according to the facts. In this particular case, the worker had an imposed schedule by the employer. The lunch break was then considered to be part of the work organization. Without an imposed schedule, this would probably not have been considered as a work-related accident. So in this specific case, the reason the worker was at home on that day, so he was there between 6 a.m. to 1 p.m., was to fulfill her professional obligations. The schedule was determined by the employer, as the worker had to be connected to the employer's network at the time he had determined. Within this schedule, the employer allowed the workers to take breaks and time for dinner. These breaks are therefore part of the work organization as it is determined by the employer. In addition, in this particular case, there was temporal proximity. So by the time he disconnected to the employer's network and the fall, it was really a close gap of time. This is what makes it a work-related activity according to the judge. But what we really want you guys to understand is that it is really a case-by-case basis, and it is according to the facts that the court will analyze if it is a work-related or not accident.
Thank you, Isabelle. And of course, similar considerations in British Columbia regarding things that butt up against workplace activity. What I wanted to talk about was a recent case just came out in January of this year regarding traveling employees. Now, the case itself is all about the exceptions for traveling employees, but by talking about the exceptions, I hope it will help inform you about the general application and where your employees might fall. In this case, employees of Delta Airlines based out of the United States were injured when they were traveling back from their hotel to the airport and were involved in a motor vehicle accident. And these employees were on a turnaround, so they'd landed most of their work, well, all of their work really was conducted on the airplane, but they needed to stay at a hotel overnight before returning to working on the airplane. As you may be aware, British Columbia is a mandatory registration jurisdiction, so all employers operating in the province need to register. This is unlike Alberta or Ontario, for example, where certain industries may be excluded from the workers' compensation regime. And British Columbia, similar to other jurisdictions, workers who engage in travel have a much broader scope of activity of what might constitute out of in the course of this employment. So we're hearing with taking lunch, is that out of in the course of employment when there's a set schedule? And this is workers who are traveling to the work site. Are they out of in the course of employment? Normally a regular commute. The general rule is that would not be a workplace activity, but where you're traveling to remote work locations or traveling for business, that certainly can become a workplace activity. In this case, the employees had commenced a personal injury action in the British Columbia Supreme Court, which was opposed by Brown Brothers on the basis of what we call the historic compromise, i.e. that employers fund the workers' compensation regime, and in exchange, workers give up the right to sue their employer or employers generally, depending on the application of the Act. The decision that the tribunal made was that these airline employees were not workers. They followed Wsib BC policy that was specific really to airline workers, an exclusion on turnaround flight employees. This policy itself was a codification of the 1985 BC case that determined that airline employees from foreign jurisdictions without a connection to the British Columbia were not sufficiently connected, and so not constitutionally within the jurisdiction of the province. Next slide. So on the initial judicial review, the petition was dismissed. The appellant argument that it advanced then on appeal was that the interpretation of the policy documents was not just statutory interpretation, but engaged a constitutional analysis outside of the tribunal's expertise by recognizing and adopting the constitutional analysis that had been originally set out in British Airways back in 1985. This was important for the judicial review because the standard of correctness is a much higher standard that needs to be met for an employer appealing a case or anyone appealing an administrative tribunal case than that of patently unreasonable. Or is a much easier standard, I should say, for the appellant to meet than the patently unreasonable standard. Now, in British Columbia, and this is similar in other jurisdictions, legislation sets out for the Workers' Compensation Appeal Tribunal that patent unreasonableness is the standard of review applicable for statutory interpretation, while correctness is the standard applicable for constitutional interpretation. Now, next slide. So what happened in this case? Well, the Court of Appeal denied the appeal, ruling that Wsib BC's policies incorporating the constitutional determination in British Airways does not mean that WCAT conclusion should be subject to the correctness review, saying at paragraph 41, the language of the policy does not transform its application, which is an exercise of statutory interpretation, into an exclusively constitutional analysis. The question before the courts was, were the flight crew members workers in British Columbia? And that interpretation is fundamentally a statutory interpretation question, an application of Wsib BC policy. The Court of Appeal went on to say, WCAT has always had the authority to consider constitutional principles, such as fairness and interpretation, to ensure that the interpretations of the Act were within the province's constitutional authority. They, of course, concluded that the decision that WCAT had made that these airline employees were not workers was not patently unreasonable. Employers should be aware that this decision limits the scope of appeal and further judicial reviews where the board is informed by constitutional considerations, but is not applying constitutional law in and of itself in making decisions. Now, what does this mean? Next slide. For employers generally, well, Brown Brothers was an exceptional case based on specific policy exclusions. The broad requirement for coverage typically exists for extra-provincial employers in British Columbia who are engaging workers in British Columbia. And so it's important to know employers who are not required to register in their own jurisdiction are at risk unless the employee's presence is simply only transitory in nature, like these airline employees where they're performing work in British Columbia, there's often a requirement to register. And the obligation to register in BC is separate from coverage that might exist in your home jurisdiction if your workers are traveling extra-jurisdictional, extra-provincially. So you might hear that through your workers' compensation coverage in your province, and it's similar in many provinces, although you should confirm, is that a worker who's traveling for work, who regularly resides in your jurisdiction, regularly resides in British Columbia, may have coverage through the workers' compensation regime in that province for up to 6 months while working in another jurisdiction. But that is separate from any obligation to register. So in this case, even if you are registered in your own jurisdiction and have coverage, you may need to obtain it in British Columbia. Some general rules to be aware of, and which I've seen at issue recently, is if you are registered in another jurisdiction and your workers are coming to BC for 10 days or more over 3 trips, or 15 days or more over 1 trip, then you're required to register in BC. The other issue is you have employers, for example, in Ontario or Alberta, who aren't required to register in their jurisdiction because they're an excluded industry. they are required to register regardless of the length of time in British Columbia. So, people, for example, in the film industry, in advertising, things like that, maybe who are coming to work in British Columbia in our film industry, even if it's just for a few days, there's a requirement to register if you haven't registered in Ontario or Alberta or elsewhere. So how does Brown Bros compare to other cases? There's a case back in 2004, but for the BC Supreme Court, Harris in British Columbia. In this case, the employee had been working in BC for 5 days, so presently under that 10 to 15 day threshold, and their employer was registered back home. But they were planning on returning to British Columbia for additional work throughout the year. Unfortunately, during that 5-day visit, they were injured, and they argued that they had no substantial connection to BC. And so they shouldn't be required to follow through the workers' compensation regime. You see this happening a lot because the potential compensation often is greater through, say, for example, a motor vehicle accident than through the workers' compensation regime. So there's a preference to be excluded, if possible, by many individuals. But once again, they argued there was no substantial connection to BC, but it was upheld that the worker's presence or the intended presence in the future trips that had been planned for that year was sufficient, and that a hotel room where this injury occurred was different than an airplane, for example, where the hotel is fixed in British Columbia as an airplane is a transitory thing that generally exists outside of the jurisdiction of the province. Now, what does this say for employers with remote workers? Employers who have remote workers who've relocated to British Columbia need to register and obtain coverage. That's true if it's a single worker or if it's a large number of workers. There's an absolute requirement to register. You might be happy to know, though, that remote workers who are only servicing extra-provincial entities or clients outside of British Columbia have one of the lowest rate groups in BC. So although there will be a requirement to pay premiums, it is less of a burden, let's say, than in other workplaces. I'm now going to pass the presentation off to David, who's going to speak to specific considerations regarding remote work.
Fantastic. Thanks, Richard. The timing of this presentation is important because a lot of employers are turning their minds more so to whether they're going to have ongoing remote work and ongoing telework, where 2 years ago it was an entirely different situation where people were going into fixed workplaces 5 days a week and maybe occasionally worked from home. Now, serious consideration is being given to not only people teleworking in their home province, but whether they're working outside of the jurisdiction where their employer is. And there's a lot of considerations to go along with that from a workers' compensation and a health and safety standpoint. These are not new considerations. Certainly, there have been people who've been working from home, teleworking, people who have been on call, et cetera, for many, many years, and they've been covered by the workers' compensation system. And when an incident occurs, then consideration has to be given to the circumstances of that incident to determine whether it is compensable, meaning that it's a workers' compensation claim that's going to be paid through the compensation board or not. So a few of the considerations that we wanted to talk about include, whether your organization is going to continue to have workers working remotely and whether they are in the same province or location where they would have worked previously. And what are the health and safety steps that you have already taken and or that should be taken in with respect to these employees, and what information needs to be provided to them. Isabelle had touched on a few issues, and Richard as well, and we're going to continue on and talk about a number of those things. Next slide, please. So there are certainly jurisdictional issues with respect to workers' compensation. As Richard was discussing and mentioned, each province and territory has its own compensation board with its own registration requirements. Some of them depend on the number of employees that you have, while others don't. And I'll be talking about that more in a moment. Generally speaking, there are allowances made by the compensation boards for workers who normally work in one province, let's say Ontario or BC or Alberta, for example, if they have to travel to another jurisdiction for a short period of time. Let's say, for example, that their work takes them to the US or to Europe or to another Canadian jurisdiction. Each compensation board generally has a provision in their own compensation legislation that allows for workers to leave their home province to do work for a short period of time and maintain coverage. However, that is separate and apart, as Richard said, from the requirements to register in the province where the work is actually happening. I had a situation come up recently where an employer is looking to have they're based in Ontario and they're looking to have employees work from different jurisdictions on an ongoing basis, and they wanted to know if they could just continue to pay the WSIB premiums for all the employees who are working in 6 different provinces. And the short answer to that is no, they can't. You have to look at at where the work is happening and what the registration requirements are. There are registration requirements if a worker enters a province for a significant period of time. For example, and as Richard mentioned, the requirements for British Columbia, if a worker is coming into British Columbia for X amount of days over X amount of trips, for example, and Ontario has a very similar system where if you have a worker who's based out of Alberta, for example, who comes into Ontario to work and is in Ontario for approximately 10 days over the course of a year, there would be a separate obligation for that employer to register in Ontario. That doesn't mean that employers have to pay premiums in both provinces at the same time. It's actually up to the employer to segregate the payroll based on or report to each province based on the earnings earned in that province. So if you have a worker who's coming from, say, BC into Ontario and is here for 30 days over the course of a year, then the requirement to pay premiums in Ontario would only be the earnings that they had over that 30-day period. It's a bit of an accounting situation, but unfortunately, it is something that needs to be done. A question may come up as to, would the compensation board know? Well, the short answer is not unless something happens, and that's that may be true. However, they are legal requirements to register, and there are ramifications for not doing so. If I could have the next slide, please. So just as Richard had mentioned, British Columbia is a mandatory registration province. So pretty much almost every employer who has employees working or workers in the workers' compensation sphere, employees are referred to as workers because not all workers are employees. They may be contractors, for example. So I'll refer to them as workers. So there are very few exemptions from coverage. So for example, personal service corporations or personal financial holding companies are 2 of the very few exclusions from coverage in British Columbia. Other than that, all employers are required to register, regardless of whether you have 1 worker or whether you have 20. In Alberta, Manitoba, Saskatchewan, and Ontario, registration requirements depend on business activity. If your business activity is one that requires mandatory coverage, then you would be required to register regardless of the number of workers that you have. So if it is a mandatory industry, then coverage would be required. Quebec requires employers to register if they have an establishment in the province. Generally speaking, an establishment is a physical workplace. is considered to be a physical workplace. And Isabelle, please correct me if I'm incorrect, but my understanding is that that generally that is the case. You would have to have a physical establishment. If it's only telework that's being done in Quebec and workers are only working from home, but the employer does not have a physical establishment, then registration would likely not be required. However, if the employer does have an establishment in the province and also has workers teleworking, then registration would be required. In Nova Scotia and New Brunswick, interestingly, there is a requirement to register if an employer has 3 or more workers in the province. So if you only had 1 or 2 in those provinces, then registration would not be required. Whereas in Newfoundland and Labrador, again, mandatory registration province where coverage is required and registration is mandatory. This is, if I could have the next slide, please. Oh, thank you. This is important to know as an employer, especially now where workers have moved to different jurisdictions and have taken up residence there and are continuing to work remotely and may intend to do so. Employers are responsible for ensuring with the compensation board as to whether they are required to register or not. And there can be significant penalties for failing to register, ranging from anything from administrative penalties to assignment of claim costs. So for example, in some provinces, if you fail to register and a worker gets injured, then instead of the claim cost just going to your experience rating, you as an employer could get assessed with the entire cost of that claim, in addition to any retroactive premiums, et cetera, and you would still be required to register. In Ontario, it's actually an offense under the Workplace Safety and Insurance Act to fail to register within 10 days of becoming an employer, and that has a maximum potential penalty of $500,000 upon conviction. So there are very, very serious penalties for failing to register. However, an important note is that if you did not register, but you ought to be registered, and a worker becomes injured, they still can't sue you because if you ought to have been registered, then you are still protected from civil action from an employee if they become injured due to a workplace injury or illness. So that's one silver lining. However, it is important to ensure that you meet your registration requirements. Okay. A few occupational health and safety considerations. In some provinces, a worker's home is considered to be an extension of the workplace. For example, in British Columbia, and as Isabelle mentioned, in Quebec as well under the amended legislation. In other jurisdictions, for example, in Ontario, it's a lot less clear. The Occupational Health and Safety Act in Ontario excludes work that is done in a private residence by the person who lives in that residence. So there's no clear case law indicating whether that is considered to be a workplace under the legislation. However, what we recommend generally is a risk management approach for for employers who do have workers who continue to work from home. And this risk management approach is something that can be applied to all jurisdictions. So just if we could have the next slide, please. Employers who have workers who are teleworking, and certainly if teleworking was done previously and before COVID, that's something that you may have already had in place. Whereas at the beginning of the pandemic, when workers went home and were working from their dining room table or from their living room sofa, and there were all kinds of different makeshift workplaces that were originally intended for 2 weeks, and then suddenly here we are 2 years later, we need to take a different approach. Employers should certainly look, if you don't already have it, into a teleworking policy. I have a number of links that are going to be shared with all participants to some resources that you can use for the topics that we're going to be covering. A teleworking policy should include things like when the work is going to be done, requirements for having an adequate workspace that meets certain expectations for things like safety, security, and confidentiality requirements. I know that in our industry, for example, whereas we were largely paper-based even 2 years ago, that has significantly changed, and that also changes things for confidentiality purposes. So if you are having work done at home, confidentiality in a paperless environment is a lot less of an issue because everything is stored stored electronically and not easily accessible by anyone who may be coming into the live workspace, as a lot of people have it. So certainly a teleworking policy would be helpful for setting out those provisions. If teleworking is something that's going to be ongoing and is going to be considered a privilege, which it has been in the past, then that type of policy should include provisions for terminating the teleworking agreement under certain specific criteria. For example, it could be productivity requirements, etc. So a provision like that could be included. A number of questions have been asked about, for example, with respect to occupational health and safety requirements in your physical workplace where workers were coming to work. You would have monthly inspections done by the Joint Health and Safety Committee, for example, or health and safety representatives, in addition to any supervisory or management inspections. And you don't have that type of inspection that happens at people's homes. But that is something that should be taking place if there's going to be ongoing telework happening. You could provide a checklist, for example, for identifying hazards and training workers or instructing them to discuss those hazards with supervisors. For example, things like slips, trips, and falls, electronic and potential electrical hazards, overloading electrical outlets, for example. Information should be provided to workers with respect to how to mitigate those hazards, how to deal with things like extension cords, pay attention to them. You could ask employees to provide photos of their workspace, for example, and provide assistance with helping to set them up. With respect to ergonomics, Ontario doesn't have a specific ergonomics regulation where British Columbia does. If I'm not mistaken, Quebec also does not have a specific ergonomic regulation, but there are general requirements for employers to ensure that they take all precautions reasonable in the circumstances to protect worker health and safety. Typically speaking, work that can be done from home is administrative type of work, and it involves a lot of sitting. As we've seen over the last 2 years, we sit a lot more when we're doing work from home than we do when we're going into an office workspace. You get up a lot more, you go to meetings, you go to different places, whereas at home you tend to sit a lot more. So as far as ergonomic considerations, information and instruction should be provided to workers about how to set up their home workspace, how to set it up ergonomically, and how to be safe while doing that. There are a number of free resources available from WorkSafe BC that can be very instructive with respect to this, and we're going to be sharing some of that those links in the chat for you as well, so that you can access those. I encourage you to access those free resources and provide them to your employees so that they can set themselves up properly and be able to work without developing repetitive strain types of injuries, etc. Information and instruction should also be provided with respect to working alone or in isolation. As Isabelle mentioned, there are considerations with respect to workplace violence and harassment, and not only spousal considerations, but workplace violence and harassment generally when people are working from home. British Columbia does have a specific requirement in its occupational health and safety regulations for ensuring that an employer has check-in and communication procedures. Check-in and communication procedures can be as simple as using electronic functions on, for example, MS Teams, for people to be, accessible, seeing that they're online, ongoing email communications, making sure that that you hear from them, throughout the day, for example, and that you have procedures for being able to do that. So there are specific requirements in place in BC that, in our opinion, if you take the most stringent requirements in the country and apply them across the country, then you are likely to be compliant and meeting your health and safety requirements. In addition to that, you should put into place incident reporting protocols. Workers should know and understand their obligations for reporting any workplace, any incidents that happen at work, if they think they're work related or not. How do they go about reporting? Who do they report to? And when should that happen? Is it done by phone? Is it done by email? In addition to reporting injuries, employers should have a mechanism in place to investigate. Whereas an incident that happens in your physical workplace, you'd be able to go and investigate the incident, take photographs, for example. You wouldn't be able to do that if a worker is teleworking or working from home. However, I think it would be fair to ask them to take photographs and to send them to you, indicating where exactly the incident occurred. It would also be fair and reasonably expected, in my opinion, that they would participate in any investigation as they would anyway, and give a statement. As an employer, you want to know all the details. When did it happen? Where did it happen? And exactly how did it happen? These are important for occupational health and safety reasons and for workers' compensation reasons, as external reporting may be required with respect to these issues. Next slide, please. On that specifically, a lot of employers make what I consider to be a mistake about determining themselves whether an injury is work-related or not. The workers' compensation legislation right across the country gives the compensation boards, each of the compensation boards, exclusive jurisdiction to determine whether an injury is work-related or not. If a worker thinks that an injury is work-related, or they request that a workers' compensation claim be made, then the employer needs to report. And certainly it is within an employer's right to dispute any claim that they think is not work-related. However, the obligation to report is there. When determining whether an injury is work-related, especially when it's happened at home, but the same criteria is reviewed, and those criteria include time, place, and activity. When did the incident occur? Did it happen during normal work hours or a time that is reasonably around those work hours? In the example that Isabelle provided in the Air Canada case, the incident occurred within a very short period of time of the worker actually going on break. So it was considered, as they refer to it, to be contemporaneous and reasonably related to work. Where did the incident occur? Was it within a designated workspace? As part of your teleworking agreement or work from home agreement, it would be important to designate a space that would be considered to be the workspace. Does that include the kitchen? Does that include the bathroom? On the Wsib website, they make the same recommendations. They suggest having a formal work from home policy or remote work agreement that sets out those specifics if possible. While that won't guarantee you that a claim that occurs, would not be considered work related, it can help with the adjudication of the claim. And each claim, and the last criteria is activity. So what exactly was the worker doing at the time? So simply walking down the stairs to go and grab some lunch from the kitchen, for example, or even if you had a one-level living space, if you slipped and fell, could that be considered to be work-related? Potentially, because it really just depends on all of the other factors. However, each case and it doesn't matter whether a person's working at home, working in the physical workplace or not. Each case will be determined on its own facts. If you have an office environment, and let's say that you had an office environment in an office building, there are certain parts of the workplace that are considered to be your workplace, even if you have no control over them. So, for example, elevators and lobbies could still be considered part of the workplace, even though you don't inspect them and you don't have specific control over them. But each case will be determined on its own merits and based on its own facts. Workers' compensation law, I've had a number of employers and clients ask about, whether something is precedent setting. Not really, because one fact can change a determination as to whether something is work-related or not. If I was walking down the stairs, for example, to go and get some lunch during a lunch break, it's reasonably expected that I would take lunch and that I would go to my kitchen to get lunch. However, if I was carrying a laundry basket downstairs and I slipped and fell, that fact alone could move from work-related to not. If I decided to go and shovel my driveway during lunch because it was snowing, for example, and I injured my back while doing that, well, that's not something that would be reasonably expected as part of my work. So that likely would not be considered to be work-related. So each fact would have to be considered, and it's very important as part of the investigation process to gather as many facts as possible with respect to exactly what, where, and when things happened in order to assist with the adjudication process. But again, if a worker thinks that an injury or an incident is work-related, then it's important that the employer report it. Certainly, it is within your right to dispute it and appeal any decision you don't agree with. However, I would refrain from what is referred to as self-adjudication and ensure that you report in a timely manner. Okay. Next slide, please. Just before we move on from there, with respect to the health and safety considerations, Richard, did you have anything to add, or Isabelle?
I just had a few quirks to add. BC, as we've been hearing, is a quirky province when it comes to health and safety and workers' compensation. So, for example, for the check process, in BC, it's required to have a check-in process for workers working alone or in isolation, and certainly that would include many remote workers. But it's required for workers who have a set schedule. So if you have employees who work regularly, who set their own hours, then you aren't expected or required under the health and safety regime to have that check-in process. Another thing to consider is in BC, because a home office is considered like any other work site, the worker in that case would be the owner under the Workers' Compensation Act of the work site. And so they have obligations not only as a worker, but as an owner to identify hazards in the workplace and communicate those with you. And so that's why using, for example, like a checklist, as David was talking about, to go through ergonomics, risk of violence, including domestic violence, slip and falls, things like that, with a worker is very valuable, and placing an obligation on them to let you know about hazards in the workplace. Another quirk that I see in BC, once again, because it's a workplace, is the first aid requirements in BC. There's a requirement to keep first aid records in the workplace. So, if they're keeping a copy of their hazard assessment checklist and there's a workplace incident, there'd be a requirement to store first aid records, and also to potentially provide a basic first aid kit if they are working in a remote location. So that would be more than 20 minutes surface travel from a hospital or emergency center. So those are some specific considerations to BC, but as David was saying, if you're applying best practices, probably relevant to your operations generally in Canada.
Fantastic, thank you. Okay, we're going to move on to the question and answer portion of today's program, and there were a number of questions that were sent to us that we are going to review, and Just bear with me a moment. So we already touched on actually, just before we get there, that one of the first questions that that came in today that I'll answer quickly was about the WSIB rebates, the 1.5 billion that's being rebated to eligible employers. The question was, when will this rebate be paid to employers? According to the WSIB website, that rebate is to be paid out to employers sometime in April of 2022, so just coming up, and it will show on the employer's excuse me, on the employer's account. So that is my understanding, that it's supposed to be done in April of 2022, and you should receive that on your account. So you may want to follow up with the WSIB on that. And I shared a link with respect to with the WSIB's website on those rebates, so you have some more information on that. Okay. So a question came in that if WCB registration is not required in a jurisdiction and a work-related injury or illness occurs, what is the result? The employee has no access to benefits and is not barred from an action against the employer. Richard, do you have any thoughts on that?
Yeah, I think that's a pretty fair assessment. What we talked about earlier, this historic compromise, people giving up the right to pursue private action in exchange for employers funding the workers' compensation regime. Where people are outside of that regime, then they would be able to pursue a personal injury action just like any other individual who's injured by an employer, like someone on the street who's injured by an employer or its practices. As I was saying, just as the workers' compensation regime in some ways caps entitlement to benefits. We've seen in the common law and personal injury claims higher awards than you might get through workers' compensation. And so typically individuals are arguing that they should be held outside of the regime if it's, for example, a motor vehicle accident where there's a pot of gold that could be accessed. In other cases, they might want to be within the workers' compensation regime because the employer might be insolvent in the case of a workers' compensation claim where there's substantial injury. I see that there was a follow-up to that, so I think I'll just address that as well. If an employer is registered in BC but not Ontario, and a BC employee relocates to Ontario as a permanent remote worker and then is injured in a work-related way, is the employer exposed to liability it would have been exposed in BC? So this is kind of a conflict of laws on this jurisdiction question. So they wouldn't be able to pursue a claim for personal injury in BC, but if the if the employee was in a non-mandatory registration industry in Ontario, it's possible that they could pursue a personal injury action in Ontario. So there is liability. There is potential for liability. They would be protected from liability in a BC action, but they wouldn't be protected in liability potentially in an Ontario action. So it can be an issue of then, where is it best to try this case? Well, if the injury occurred in Ontario, it's likely best to try it in Ontario. And so that's where you would find yourself.
Interestingly, and just to add, if an employer is not required to register in any jurisdiction, in each jurisdiction, they can choose to do so if they wanted to. So they're considered to be, employers by application or voluntary registration. Any employer that's not required to register but opts into the system can choose to opt out of the system as well. So they could choose to close their account at any point because they are not required to be registered. However, they could choose to opt into the system, which would provide protection from civil action and would give employees or workers the access to workers' compensation benefits. But that is an individual choice for employers if they want to do so. The downside to choosing to register is that once you opt into the system, you are now required to fulfill all of your obligations under that system. So, for example, premium reporting and payment, accident and injury reporting, reemployment obligations, and return to work accommodations. All of those requirements under the workers' compensation regime would then be required of you. But I think it was important just to advise that that there is the ability to register should you choose to do so, and if registration is not required. There's another question that came in and said, what are our obligations if we have remote workers outside of the country? Are we required to obtain coverage in that country? And I'm going to be honest, I really don't know the answer to that question, because it really is jurisdictional, right? The law of the land applies, and that really. So I'm going to be honest and say I don't know the answer to that question.
I think it's fair to say many jurisdictions have workers' compensation regimes, and so I've seen where employers have been asking that question. Often the answer is yes. If an employee relocates to another jurisdiction, you're going to have to consider compliance with occupational health and safety, workers' compensation, taxation, and all those other issues, employment issues that you find in that jurisdiction. So it can be a bit of a minefield to navigate.
Another question that came in Ontario, if an employer identifies a hazard in an employee's designated workspace, does the employer have the right to force the employee to implement a safety measure? For example, if the stairs are slippery, can we ask them to wear rubber-soled shoes inside their home? That's an interesting question. I think that you could ask them to do it. I don't think that you can force them to do it. They are within their own home. I'm going to leave it there for a second, because I see that Richard may have a comment, and then I'm going to come back to this in a second.
Yeah, I think David's on the right track. The other thing that I would consider is employers have an obligation to ensure health and safety in the workplace. So, for example, in BC, where the home office is the workplace, they have an obligation to ensure health, that safe practices are kept there. If an employee is living in a derelict shack, let's say, or something that's unsafe, fundamentally unsafe, or where there's hazards in the workplace that can't be addressed, then the employer has an obligation to not allow that worker to work in an unsafe workspace. So that might be a situation where, slippery floors, I think it's reasonable to say, okay, how are we going to address this hazard of slippery floors? But if there's something more substantial, it may be that, okay, this worker can't work remotely. They're going to have to be coming to the office because they don't have a safe work site, and we need to address that hazard in the work site. So,
yeah, I think that's a really fair comment, because again, teleworking may have been part of somebody's job in the past, but may not have. And if that's the case, then and it's for health and safety reasons that you want them to come in, then I think that that's fair. The other part of this is that just like any other type of working environment, you as an employer can give people information and instruction. You can give them the tools to do the work, and you can ask them to do it in a certain way. If for some reason they don't do it, so for example, in this case, let's say that an employee says, "Sure, I'll wear shoes while I'm in the house," and then they don't, and then they fall down the stairs. That would still be a compensable issue. It's still reportable to the Workers' Compensation Board, and they may still get benefits because it's a no-fault insurance system. So I think it's fair to ask them to do it, but whether they do or not is an entirely different scenario. Even within your own workplace, providing information and instruction on ergonomics should be done. Workers should be advised on how to set up and work in an ergonomic manner. If they don't, and they develop a repetitive strain injury, because of their work, then it is still compensable, even if they weren't following proper protocols. So that's the wonderful world. If a BC employee works from home and the employer uses its best efforts to ensure that the workplace is safe, but the employee is injured, is the employer liable, and how can the employer mitigate its damages?
Well, so my thoughts there are, so we have a worker with a compensable claim. They've done what's best to ensure it's safe, but the employee's injured. As David was saying, it's a no-fault system. So in terms of mitigation of damages, for most employers most employers are not self-insured. They participate in the insurance regime. So mitigation of damages is really addresses return to work, accommodations to return the employee to work to limit the claims costs. And so it would be no different than any other workers' compensation claim. How do we address claims costs? Working from home is very light work. So if a worker is able to work in any way, they're likely able to work from home. That may not always be the case, but so early return to work, selective light employment, whatever you can do to address returning the work to the workplace, that's the best way to address claims costs after a legitimate claim has occurred. If in these fringe cases, for example, if the worker is injured and you don't think that the claim is legitimate because perhaps they were, digging up their backyard or something like that, then in that case, then you could challenge the claim just like you would challenge any other claim.
Yeah, I would agree with that, and the biggest issue that employers typically have with workers' compensation claims is the costs and try to mitigate those costs. In the absence of some very significant injury that happens at home, a worker should be able to continue to do their very administrative tasks that we're doing. So, let's say, for example, they slipped and fell and had a concussion. Well, in that case, they may not be able to use a computer. They may not be able to look at a computer screen, et cetera. So, fine. And you have to deal with that. But if they slipped and fell and, they needed to kind of sit and stand as required, if they needed to take discretionary breaks, all of those things can happen, especially working from home. And, we remove one of the key obstacles that we would see with respect to return to work plans, and that's how they get to and from work. Well, no longer an issue. So you can get set up someplace else and continue to do the work, at least at partial hours, thereby mitigating your workers' compensation costs. Certainly not ideal, but we want to rein in the cost as much as possible. So the making the argument that you're unable to perform any suitable work is pretty tough to do. There was a question about whether Fasken is dealing with any claims or appeals for COVID-19 claims where workers are diagnosed with PTSD, as it seems that those claims are increasing. Certainly, that is something that we can assist with, and if a claim is made for traumatic mental stress because a worker contracted COVID-19, there are certain criteria that would need to be met. A lot of claims that came up for COVID-19 or that arose from COVID-19, especially with the Ontario employers that I've been dealing with, they haven't been taking a lot of action on them just because costs were not being allocated to employers for COVID-19 claims. So that is certainly something that we could assist with if you do need assistance. So a question came in that, would an employer in Quebec have a right to inspect a remote workplace to ensure that it is safe and free of hazards? I'm assuming that the question is about going into a worker's home to do that inspection.
Hi, David. I can answer this question. So yes, what we recommend is to first ask photos of the workspace, to not systematically go into the private home. But if this is not an option or it does not satisfy your needs, well, it is obviously limited to human rights and privacy. So you need to limit the visit to really the workplace, and you need to ask the worker, have an appointment, and this is the kind of things that we do recommend.
Fantastic, thank you. So a question came in that, so are the rules the same if someone is working from home voluntarily or on a compulsory basis? So the health and safety and workers' compensation rules, would they be the same if somebody's working from home voluntarily or on a compulsory basis? I would say yes.
I agree. I think I would say yes. an issue that I was toying with in my mind just as we were talking about this was a remote worker who travels not for the benefit of the employer, but for, and so this is not where someone's relocated now is residing, but a remote worker who travels for their own benefit but is performing work for the employer, but not specific to that jurisdiction. I would say that then that's likely not a situation where registration is required. Of course, devil's in the details, so you really need to consider. But where a worker is traveling, say on holiday to a Caribbean island and decides that it's a working holiday and is performing work remotely, then that's something where you look to the compensation of the jurisdiction where they regularly reside, and that they're unlikely to need to register in that jurisdiction. Although, of course, as we said, outside of Canada, it becomes difficult for us to advise on any specifics for any specific jurisdiction.
We did get a question about that. If someone was on if they were away on a work holiday, sort of a split work holiday, and in a different jurisdiction, would they be covered, et cetera. As I mentioned before, if somebody is away from their home jurisdiction, so for example, in Ontario, if you're away temporarily, then your coverage does follow you if you are away for work, except that in that case, you are not away for work. You are away for holiday and you are doing some work. That would be in my mind, that would be a very difficult case to adjudicate in terms of determining that something was work related. Because if I was doing work, for example, I would likely be sitting at a table, typing out some emails, et cetera. And then, worst case scenario, I might, get up from there and go get something to eat. You've essentially just changed work. You've essentially changed work locations, but the employer has zero, control over that work environment at all, and likely wouldn't have any information about it. When you start meshing together vacation and work, the lines which were already gray become almost white. So it can be very difficult to delineate. But gather as much information as you can, and ultimately, like I said, if a worker thinks it's work related and wants you to report it, then certainly it should be reported, and it will be adjudicated based on the available information. Won't workers' comp costs be reduced if all workers are working from home? I would say generally, yeah, absolutely. Yeah.
You think about sort of captive parking lot claims, things like there's claims that just won't exist with a worker working from home. Of course, you might think there's an increase of maybe claims that aren't wholly work related, but I would think, for example, BC, as I was saying, has a rate group for workers who are only servicing employers in other jurisdictions, and it's the lowest rate group in the jurisdiction. And that's because people who are sitting in front of computers or what have you working have very low claim rates, and the claims are primarily soft tissue injuries. And so if you're removing other factors that might lead to workplace injuries, I think that yes, particularly if you incorporate policies, as we discussed, best practices around working from home.
Yeah, I would agree. The slip and fall in the parking lot, interestingly, there are claims that come about with respect to extracurricular activities that have happened too. Company-sponsored sporting events, picnics, offsite meetings where things have happened. For the last 2 years, there have been none of those. Absolutely zero. So certainly, workers' compensation costs have gone down, which is part of the reason that if you have less monies being paid out, then the WSIB, for example, could end up in a surplus situation where they're rebating employers back. So that is certainly the case where there are certain claims that just won't exist with respect to when people are working from home, but you have other issues, like we said. Just looking to see if there's any additional questions that.
There's a question I thought that was kind of interesting, David, that it was about the right to disconnect and health and safety considerations. And the right to disconnect is not, it's Ontario, it's not a British Columbia thing, but my thoughts generally would be, in terms of occupational health and safety, employers have an obligation to ensure their employees aren't impaired. And so if someone's working extremely long hours, you could have an issue with impairment, and also mental stress claims in terms of, in BC, what we would call significant stressors. And significant stressors are those outside of the ordinary course of employees' employment. So the employee is expected to work, longer hours, and that's regularly what they do. That alone is unlikely to be a significant stressor, but in an extreme circumstance, you could see the right to disconnect and health and safety meshing where there's issues of impairment or mental stress.
Yes, and there is actually a webinar coming up, a right to disconnect webinar coming up in May. If you'd like to register for that as well. If the employee was negligent during the course of their work because they didn't have a safe work environment, can the employer claim the costs against them? The short answer to that is no. This is a no-fault. The workers' compensation scheme right across Canada is a no-fault insurance system. You actually cannot, by law, charge back employees for the costs of premiums, the cost of an injury. If you got hit with an external penalty for a reemployment breach, for example, none of those could be assessed back to the employer. So no, employers cannot claim the costs against the employee, even if they were negligent and the author of their own demise, as they say.
Yeah, one thing I would say to that, which is not a claims cost per se, is you could challenge a claim if the worker's conduct removes them from the course of employment. So that's where I would approach that, not with claims cost itself, but if the worker's engaged in willful misconduct, which removes them from the course of their employment, there could be a challenge to the claims.
Isabelle, did you have a comment on that as well?
Yeah, well, small comments. In Quebec, there is a slight difference. We do have, if considering the type of negligence, employers can demand or contest the decision, but it really depends on the type of negligence. It has to be intentional, and there is a slight difference in Quebec.
Yeah, we have the same. It's the same in Ontario. If it's a willful and intentional act, but it has to be both serious and willful. But it's interesting because the Ontario legislation says that even if it is serious and willful, if the worker has a serious injury or dies, they're still entitled to compensation. So there's that. Does the recommendation to limit the workspace to a certain area in the home, is that applicable to Quebec as well?
Yes. As I said, it is preferable to limit the home, and this applies in Quebec too. It is human rights and privacy, and we do recommend this in Quebec.
If an employee works from home in Ontario for a company based in Quebec, is the employer subject to the Labor Standards Act in Ontario? Well, the Occupational Health and Safety Act in Ontario would certainly apply. How about on the employment standards side? How about that?
From my understanding is yes, it would apply. Ontario is one of those jurisdictions where if you're working in the province the Employment Standards Act of Ontario does apply. It can be different in different jurisdictions. I know Quebec, there's a live argument of an employee who is working remotely in Quebec.
Yeah, that's the case. That's the comment I wanted to bring up. It depends if it's telework or if he is there because the employer asked him to work in Ontario. So there is a slight difference. Yes.
With respect to COVID claims, not knowing the long-term effects of COVID, would the employer be on the hook for long-term costs associated with COVID claims should a worker be diagnosed in the future or suffer long-term consequences of the illness? Different jurisdictions are handling COVID claims differently. Like I mentioned before, Ontario wasn't charging employers directly for COVID claims. I think, to be fair, there is evolving policy with respect to how to adjudicate these, because it's an occupational disease, certainly, but I don't know that they know what the long-term effects are going to be. So is it possible that an employer could be charged for or on the hook for long-term effects for COVID claims from a workers' compensation standpoint? I think it's possible, but I will be honest, I'm not sure how they're going to be handled on a long-term basis.
Yeah, I echo those comments. In British Columbia, it's very, very similar. I would say definitely it's possible. COVID cases are fact specific, like many compensation cases, but there has been so far kind of spreading of claims costs among rate groups, and so we'll see as this pandemic moves more to an endemic phase, how compensation claims are handled.
And I think we'll make this I think this is going to be our last question. If an employee is injured during a voluntary work social event, is that covered under workers' comp?
So in Quebec, I can jump in, David. In Quebec, it's the same criteria as the decision I exposed today in the Air Canada case. So we would have to analyze the different the three different points I pointed out. So it depends if it's in the personal sphere or the professional sphere, and it would be based on facts.
Go ahead, Richard.
Oh, I echo that exactly. Yes, in most cases, volunteer work. If it's for personal benefit and not for the employer's benefit, it takes you outside of the employment. But if it's for the employer's benefit, then there's likely a connection that could establish a compensation claim.
Those are very interesting scenarios, and I know that certainly in my practice, I've read decisions that have gone both ways. With respect to those issues, was it in fact voluntary, or was it voluntary but it's expected that everybody's going to be there? There are certain nuances. It really, and a lot of those decisions go all the way to the appeals tribunals, because the lower levels of the compensation boards may not allow it, but workers oftentimes pursue them all the way to the appeals tribunal. Yeah, so it's going to be fact specific for sure.
Absolutely. I think we're just coming up on time now, so I just wanted to thank David and Isabelle for presenting today, and for all of you for joining us. As a reminder, please fill out your surveys if you haven't already done so, and that we'll be having another webinar on April 26th. So please keep an eye out on your inbox for the Fasken Institute section, or the Fasken Institute section at fasken.com. And whether it's morning or afternoon, enjoy the rest of your day today. Thank you for joining us.